and copyrights and GI practice. Recognized by WTR 1000, he specializes in trademarks, copyright, anti-counterfeiting, criminal enforcement, and domain name disputes. Welcome, sir. Now I'd like to hand over the proceedings to Dr. Venkat Reddy for this session, which is Impact of Emerging Technologies on Non-Traditional Trademarks. Over to you, sir.
Thank you. Good afternoon to everyone. And first of all, thank you for GIPC giving this chance and opportunity to be a moderator here for this session. And precisely out of all the sessions we worked out, this could be the toughest session. It could have been in the morning. But unfortunately, it is in the evening. And before we get into this, all the speakers were asking me, sir, what to speak on this. This is a non-traditional trademarks. There is no much content on this. But we had a lot of groundwork done. After the groundwork being done, they are asking the time, sir, they should know 40 minutes is not sufficient for this. So I am very happy. My panel speakers are well prepared for this. And second issue also, it is not biased. Two ladies and two gentlemen here. And getting into this even, I was wondering what is this? First of all, impact of emerging technologies, non-traditional trademarks. Technology is emerging, not happened so far. And what could be the impact? What are these non-traditional trademarks? We all know the trademarks, what are the trademarks and service marks and all those. But being a counsel and being a senior advocate, I got my limitations on this. Because I was looking from the legal point of view where we stand. When I read about the section 2.1 ZB, what it defines the trademark. But precisely it says that there should be a graphical representation. Number one, other person should be infringing that. And number three, shape of the goods and services and trademarks are involved in this. Then where you accommodate these non-traditional trademarks? Are we really equipped to discuss on this point? First and foremost, my personal opinion could be because a lot of forums like this should happen. A recommendation should go to the government. There could be international conventions. Then law should come. And all of you, one of the speakers in the earlier panels were talking on this. Law is dynamic. As society changes, technology changes, law should catch it up. That's what exactly we are also into this now. I'm thankful to Dhanpatram Agarwal selecting this particular topic. I'm sure these suggestions given by my panel speakers should be taken forward to the government. And it's not only the conducting the seminars or workshops, the recommendation should go to the government so that it will be useful for the coming generations and it will be evolution of the new jurisprudence. Likewise, we have seen in the lot of what is happening in the litigation side, we never heard of. And that evolution of the new jurisprudence only happens in the intellectual property rights. Like we never heard about the John Doe orders in other conventional litigations, like quiet action, Mareva injunction, and all kind of these orders would happen only this. Anyhow, coming to the point now, let us not waste the time. We have been given a very limited time. There are 4 speakers. Now, section 2 ZB, of course, it is stated. Now, what are these non-traditional trademarks? And those were the non-traditional trademarks earlier. I put it as sound marks. Now that has become more of traditional now. At least to the extent of sound marks, we can see connotations of the different music connotations can be recorded. It may be to some extent a graphical representation. But how to give a graphical representation to touch mark, smell mark, and holograms, and is again a motion and movement trademarks. These are all non-traditional trademarks. How could you define? Now, as I said, law is dynamic. The evolution of jurisprudence should happen on this. And when the law comes, again, amendments happen when the judicial precedents keep happening in the subject field. And on this point, we have got a panel speakers who will be speaking on the different, I don't want to get into their domain, but precisely we search it thoroughly because of course we are all depending on the information available on the net. And of such, there is no jurisprudence on this point or judicial precedents happened in India, to my knowledge at least, directly touching upon the non-traditional trademarks. I belong to the place called Hyderabad, We know there we called it as attar. Attar in the sense some sort of scent is very famous. One lane is completely dedicated to this kind of attar attar, we call it is a Urdu word. So I was wondering, can I take it up for a registration, but unless somebody comes forward, but how to register it is a challenging. So these are all issues. What is the emerging technologies coming in this? How artificial intelligence and metaverse, blockchain, NFT, and meta, all those issues can be discussed by my panel speakers. And before I get into this, I want to introduce my panel speakers. One is from Germany all the way for this particular session. I took the liberty to call her as not Silke Freund and all. She is my silk friend. So I'm very sorry for, I'm very poor in pronouncing the names of it, especially for Europeans and Germany. And she's a silk friend. She's from Bomet and Bomet, and one of the prime sponsors for this event. And thankful for Mr. Dhanpatram Agarwal to bring all such a top speakers to my session. And she will be taking us on the European law perspective. And she will also be discussing on the artificial intelligence and change and amendments of the trademark law in those countries. I was also not knowing, she was telling me that a graphical representation is the word. I am sure it is removed from their act. She will take us on to that. And second is Paulo Mehta, one of the leading law firm. She is representing as a Lex Orbis. And she's the first time speaker, but she's very confident on this now. And she was a bit worried about the first examination for her, but she is going to be a successful speaker in this. And she will be discussing on the metaverse and vis-a-vis non-traditional trademarks. And next is Philip Abraham. And he will be taking us to scintillating aspects. I think this strength is really impressive. And he will taking us some of the sounds we have to, there will be a test for you people also. He will be taking on that aspect. And last, finally, Mr. Ashish Chang Mesberang. I was just worried about talking his name also. I asked him, which I was thinking is from Thailand. No, he said he is from northeast of India. I'm so thankful to you, sir. And he is well prepared. He is discussing on the point of execution and the litigation. Suppose somebody is infringing his non-traditional trademarks, it is very difficult to prove in the court. As a counsels, we know how difficult it is. Just 1 week back, in my part of India, I was arguing one of the patent matter. I explained to that particular judge, this is so-and-so, so-and-so. What is this, Mr. Reddy? That is interestingly fruit fly trap. She was asking Mr. Reddy, there is a fly on my table, can you catch it? So this was so challenging for a counsel to convince. Unless you are also, if you're not a technical background, you have to get thoroughly with that. He will taking us to that session. And handing over mic to Mr. Philip Abraham is the first batsman for my session. Thank you.
Good afternoon, everyone. I will first start by saying what is a non-traditional trademark. In my understanding, a non-traditional trademark is something that you cannot see, but perceive. So most of the non-traditional trademarks or marks that were considered as non-traditional trademarks have now come into the common domain used by companies to identify themselves or to have a source of origin. Now, there is sufficient scientific research to suggest that the human mind can remember sound marks the most amongst the non-traditional trademarks. So what is a sound mark? A sound mark is something that once you hear the sound, you are able to identify the source of origin. So here, I'm going to play some sounds for you. It'll also help you get out of stupor after a good meal. And given the time of the day, it'll be useful for you as well. So here goes the first one. Which one? That is confusion. Imperfect.
Then there is infringement also.
Okay, here's the second one. Perfect. Well done. Here goes the third one. What was that? Okay, wonderful.
I'm loving it.
Take your time. It's not. It's 20th century fox. So here's the last one. Yes. So, so my endeavor today will be to point out the pitfalls of marrying emerging technology with non-conventional trademarks. So here on, I think Silke will take on, and she will explain what is happening in the European Union.
Good afternoon, everyone. First of all, thank you for having me here all this way, and I think I will keep this name, Silke Freund. It's wonderful. And I'm also happy to be on such a diverse panel. So we have women, we have young people, older people, so that's diversity pure. So I'm very happy to be here. Yeah, and I'm here to give you some insight of the EU perspective, which is a bit different than, for example, the Indian perspective, since, as we heard already, you still have this requirement of graphical representation. And in the EU, some of the non-traditional trademarks, such as smell marks, are also still not acceptable. So you won't find any registered smell marks on the EU register. But the EU law has done, or the European Union has done its homework already. So, yeah, using new technologies would be allowed, since according to the EU directive from 2015 already, the graphical requirement is not necessary anymore. So you might question yourself, how would a law look like if there's no graphical representation anymore? And I will let you know the concrete provision in law. It says, the trademark shall be represented in any appropriate form, and now important, using generally available technology, as long as it can be reproduced on the register in a clear, precise, self-contained, easily accessible, intelligible, durable, and objective manner, so as to enable the competent authorities and the public to determine with clarity and precision the subject matter of the protection afforded to its proprietor. So the most important element was using generally available technology. So if there would be generally available technology, then that could be used to reproduce a non-traditional trademark. When I first read our topic of today, I had the impression that I'm totally blank because there's no real technology yet. Moreover, I'm an attorney at law with no technical knowledge at all. But if you dig a bit deeper in this topic and do some research, then you notice that there is technology already. For example, there is AI technology already that, for example, could help to identify, specify, and also store scents, for example. So you may have heard of this so-called e-nose. So that might be quite interesting for the future, because if we move forward with this technology, this indeed might help us to represent a smell mark, for example. And this might be quite interesting for the marketing industry, because if it comes to verbal information, humans forget verbal information relatively quick. Whereas, for example, when it comes to smells, on average, humans can recall 10,000 smells. So that's a lot. And we can also remember 65% of smells after a year. So smell, and you might have experienced this already, if you go to certain shops, they are using smells to make you feel comfortable, to make you buy the product. Also the product has, or certain products have smells. So smell is quite an important tool for brand management nowadays. So this industry has a strong wish, and they are keen to have smell marks. So I really hope that any sort of AI tool might bring us to the situation to get the smell marks registered. So, I mean, we in the EU, we are prepared. We no longer have this graphical presentation, so we are just waiting for the technology. That was my insight. Thank you so much.
Now, as already the speaker's topic is decided, I think now next Palom can talk on this. Metaverse versus this non-traditional trademark.
Hello. Hi, good evening. So what I think is going to be an issue in the virtual reality with terms of non-traditional trademarks would be how would a brand want to, seek protection, and in what manner would they want to seek protection for their non-traditional trademarks? Reason I say, in the traditional aspect, if you see, goods today are being registered even under class 9 and class 42. They are already aiming to get registration on their online downloadable goods. So similarly, how is one to get this kind of protection in the virtual world is something that needs to be clarified, because that's still in the gray area. Another situation that I think would come up, with the virtual world and non-conventional, or, even for that matter, traditional, both, it would apply to both in general, is how is one to keep finding infringers, and how are you to find multiple infringers in the virtual space? That's another thing. Another thing is what would be considered as infringement in the virtual space. So far, as of today, there isn't any judgment or anything of that sort with non-conventional trademarks. But what has come across is there is one matter which I came across in traditional trademarks, which is the Metaverse matter. Now, of course, here it's, again, moving to traditional, but trademark law is applicable to traditional and non-traditional trademarks at the end of it, because they're trademarks. So their court had held that there was infringement. Surprisingly, here the plaintiff had its goods being sold in the physical world, but the defendant was the infringer in the virtual world. So was that to be considered as, an infringement? was something that was put forth before court. And what it held was that, is there really a likelihood of confusion anticipated? Most consumers that were buying the NFTs, which were sold under the brand name of Meta Birkins, were buying it thinking it's associated with the Hermes Birkin bag. Now, the virtual bag had just fur put on it, and it, gave a misrepresentation of that it is associated with the Hermes bag. So that's when court said that even though the goods are, associated in the virtual world, it's still amounting to infringement. So your goods are protected whether they are in the physical or in the virtual world. But how is that to be analyzed in, the non-traditional trademarks? That's something which we will have to only wait and watch.
Now, when we file the trademark applications, all of us as practitioners and the litigation counsels, we know that these marks to be filed in particular classification of the goods. But precisely, what my understanding goes with, all of us file the application as a routine, one particular application in the class 9. And remaining, wherever it doesn't fall, we'll put it in the class 42. But the question is whether non-traditional trademarks in which classification we have to file, that is one of the challenging aspects. Second issue, when we are going for a launch or coin a trademark, we do a survey and search report and all. But whether how can you do a search report for the smell marks or sound marks or remaining other texture marks or motion marks, whatever it is. Now I think it will be enlightened by Mr. Ashish.
I just have one point. When we talk about AI, I had a client who most of you have encountered, where they come and conceive a mark. So this client, methodology which he used to conceive the mark was, he used ChatGPT. So what he did was, he says, I want a mark in relation to certain goods. So ChatGPT gave around 7-8 options. Now, we as trademark lawyers understand that some marks are very descriptive and obviously will not be able to pass the test of distinctiveness and will be encountering descriptiveness objection. Nevertheless, then the second question comes that, why did you choose these marks? And then comes the fact that this mark represents a certain essence of customer awareness, or this name represents or gives an impression to a customer to feel in a particular manner in relation to that particular good. I just wanted to bring that is that because even today, there are a lot of marks that have been created. Not forget the non-traditional, but even normal marks are being used and created by AI. And that's something I thought I should just mention it. And also, even today, I mean, even our Indian Trademarks Office has an AI search, if you see it. I would say it's a very bold step. I've experimented, but I'm not sure of the accuracy. But I feel it's a very bold and innovative way to meet up the challenges that we are facing in terms of the marks that are there. In terms of trademark registration, I think Ibrahim will speak.
Yeah, I would want to say add a couple of things to what Dr. Reddy said. So when you're filing an application, you may be able to use, let's say, eNose as a technology to identify a smell mark. But is that sufficient? The answer would be no. Because now the next process is examination. At the examination stage, who is going to examine it? A human being? Or is it going to be eNose again? Now, if it is going to be eNose, then who is going to certify that eNose is error-free or completely unbiased? It is giving an output which is accurate. Then the question is, what after examination? what comes after examination is advertisement. Practical challenge. Today, our trademarks get advertised in the Trademarks Journal in a graphic form. So, how does a smell mark now get advertised in the Trademarks Journal? Now, if it is going to be a description in words, like it was done in UK, or I think it was EU registration then. This was 1996, I think, when Sumitomo Tire Company got a registration for the smell of roses in relation to tires. Now it just says a smell of roses. So is that sufficient for a human being to understand that this smell emanates from a specific company, or to kind of associate it with a company? Is that sufficient? Are our olfactory senses developed enough to understand the smell between roses, mogra, daffodils? I'm not sure. If we can, as a human being. So then, how does so the Trademarks Act says that anybody can file an opposition. It need not necessarily be a competitor. So how is that person going to understand what the mark is? There is a practical problem there. Then you come to, let's say, the question of registration. How will your registration certificate look like? Will it start emanating smell of roses? Or now we come to the consumer. It's the e-nose is a very fantastic concept, yes, but are we equipped? Let's say now we come to the consumer. At the consumer's end, we see that a human nose has to be used, not the e-nose, right? Unless that technology transcends into your handheld devices, where you can put that phone onto that smell and say, oh, this smell, now the phone tells you, this smell is akin to a smell of roses, therefore the product must be from Sumitomo Tires. That is the accurate understanding of it. Then we also come to the next leg of enforcing your right, which is even more trickier. You're filing a suit for infringement because you think that somebody else is copying your mark. Now, how are you going to represent that on the plaint? I'm not sure. Now, are the judges capable, or are they going to use their human nose, or are they going to use the e-nose, is a question that we will all have to answer. And then, again, the question of certification comes. Is that e-nose certified by everybody? Is it accurate? Is it error-free? What happens if it is not certified? The defendant comes to court tomorrow. He comes up with another technology. It is called Osmos. I think it is also a technology that is happening in Europe. So now Osmos says that these two comparative smells don't smell alike. Now who decides which technology is correct and which is not? So certification may be needed to understand if two smells are alike of the technology itself. So pitfall of marrying non-conventional trademark with emerging technology. The last aspect is we see trademarks now being filed using the WIPO or the Madrid system. Now, this e-nose technology, or whatever technology it may be, it has to be uniformly adopted by all the countries for it to be effective. Otherwise, the same thing will happen. What happens in a court of law between a plaintiff and a defendant will happen in different countries. A smell of roses may be termed as smell of daffodils in another country by the technology that they use. We don't know. So these are some pitfalls that I foresee that we will have to encounter when we are talking about emerging technology for non-conventional trademarks.
I'd just like to add, what has been said is actually so true, because if you look at even today, which is in existence, which is already at play, is your color mark. Now, obviously, if I say light blue, his light blue is different. Or our suit color is different. It's black. See, it's black. But what I'm saying is, but they have evolved and developed this Pantone shade. So they have come up with a system. So similarly, exactly, I think that's the whole problem that we are facing, is that we need to have a certain uniform way of identifying a certain smell, as has been rightly put. So I just wanted to add that.
Yes, this is quite challenging when the litigation comes to the court. Now, precisely what my observation could be, because when you file a suit for patent infringement and all, at least there is a particular provision of law say that this matter can be referred to technical expertise or some IIT professor or something to say that whether these two patents are similar or not, because you can't expect the judges to be having the knowledge on every subject. But to my subject to correction, there is no such provision in the Trademarks Act. Now, this could be an evolution. Now, this statute might have to be changed to overcome the cross-border jurisdictional issues and to bring the uniformity, as Mr. Philip rightly said. And these are all challenges for every one of us, even because the law has to evolve. And I'm quite sure, because this is since Delhi and other cities are quite competent having the original jurisdiction and the special benches are there. As the law is dynamic and jurisprudence has to follow from that, and judicial precedent would happen. And precisely earlier point of time, when I was seeing the Justice Harishankar, one of the case where Oreo versus Fabio, in my office everybody was questioning, sir, what is this, how it can be similar? But that's not on the point of the trademark, it is on the point of trade dress, of that particular packaging and all those things. Likewise, in this non-traditional trademarks also, law could definitely evolve, and that law would definitely be changing. And if any of the experience either Mr. Philip or Ashish would be having on the point of the challenging, on the point of litigation part, if any experience you had or a notice in this particular point of non-traditional trademarks infringement and all?
Just a quick thing about olfactory marks or smell marks. From the material that I read, it says human memory in relation to smells is highly reliable and could be a good indication of origin. However, there is a catch to it. Smell or taste. It's the human capability of identifying a smell or taste is nearly similar. But there is a catch to it. The catch is, it depends on your surrounding circumstances. So, when you talk about a taste mark, what is very spicy for me may not be so spicy for Dr. Reddy.
Definitely not. I'm from South India.
So, what is the parameter that we will use to now talk about a taste mark? Undecided. There is no way, even using technology, there could be, I have not seen anything in writing which says that taste marks, there are some studies that are happening, but there is nothing concrete on it. But with regard to taste again, what I read was this: taste can be subjective and variable. Basis, sensation, experience, age, food preference, consumption habits, environment where the food is consumed. Mostly when I am having a drink with my friends, the food after a few drinks, sometimes the food tastes extremely good. So, is that an indication of, is that a real indication of the taste of the food itself? So, we cannot perhaps leave it to humans to decide if a particular taste or a smell is similar. We will have to get some technology before we come down to giving registrations for these kind of trademarks. We will have to come up with technology which is user-friendly, can be used uniformly throughout the world. Everybody can use it. The judges can use it, consumer can use it, the trademarks office can use it, without which this is probably not going to happen.
Yes, one last question to my friend Silke Freund. Now, as said that Europe, there is no graphical representation. And India, it is a precisely graphical representation is the criteria for deciding a trademark. Now, the question arises when the German company, which has so far, as he said, no marks are registered. Suppose if the mark is registered, somebody violates their rights in India, then how this particular issue can be overcome, since there is no uniformity in the law all across the globe?
To be honest, I don't know. No, but
Visualizing if in the future it comes on.
That's quite an interesting question. I just want to also to respond to you. I fully agree to what you have said, but I mean, you are using also the human sense when it comes to the traditional trademark, because you see the trademark, and there might also be differences in seeing a traditional trademark. You're also using your sense, so also with different experiences might also have a different view on the traditional trademarks. I think we are facing similar problems also in this regard. Yeah.
My limited understanding, when we look at a traditional trademark, unless one is visually impaired or is colorblind, what you see would be exactly what I see. I'm not talking about artistic elements to it. Well, you may see a peacock, I may see a tiger. I'm not talking about that. I'm talking about simple written marks. So what you would see is exactly what I would see. And therefore, the non-conventional trademarks could be a little different from traditional trademarks.
I may say it so because the law in India has decided that a person of average intelligence and imperfect recollection, we use it day and out in every argument. Probably, as you rightly said, put as 2 marks of the smell, particular blind person or person who can't see, and we can smell it and say that both are similar or not.
In fact, there was a report that I read which said that if you were to serve Coca-Cola and Pepsi without the labels on it, people cannot identify which is which. Most of the people cannot identify.
That's right, really good. I think my screen shows a wrap up, and here is again 2 minutes are there for the question answers. And I also appreciate legal luminaries sitting here, Mr. Praveen Anand and Subramaniam sir and R.K. Diwan sir, and all enlighten on this subject, because we have done a limited groundwork, and extensively these people done the research with regard to smell mark and sound marks, all non-traditional trademarks. We'll be happy for that. And thanks for attending the session, sir, and especially taking your time and coming here for our session. And any questions from the audience?
Hi, good evening. It's an interesting topic. My name is Samson, and I can understand the example of roses from the tires. I'm also from Apollo Tires, their competitor. So my question is, the smell being something from natural or synthetic, So how, do you need to submit to some agents, or you need to disclose or get permission from Biodiversity Act? Do you use this for extensively using in your brands? So that would be one of my questions.
If your question is directed to filing of a trademark application for getting a registration of a smell mark, is that what your question is?
Reproducing the quality of the smell, as well as like when we use in the matters in the patent, so you have to submit the biological source and as well as get the permission from the Biodiversity Act. Similarly, this is also a materialistic aspect where you can sense it, but still it is a material rather than something colors or lines or something different. It's not a copyrighted material. So on that aspect per se, so how do you see whether you need to have some kind of acts to prevent the exploitation of these materials intensively for branding?
See, if we talk about the provisions under the Trademarks Act, I don't see there's any requirement on that context. If your question is directed and targeted towards getting some protection. So please understand, as of today, India doesn't have a smell mark. And so therefore, they don't have that provision at the moment.
There's a small correction there. Mr. Praveen Anand's office has filed for a smell mark. I think it is pending adjudication as of date.
So I have just walked in. I don't know what discussion has already taken place. Please forgive me if I'm oblivious of that and I ignored what you've already discussed. But just to add one or two factual points, I argued this matter yesterday. I'm surprised that it's on the table today. That's quick. But yesterday, the Controller General heard the arguments. The argument was the following: that graphical representation is a requirement, but graphical may mean writing. So even the word rose is good enough to evoke in the mind the smell. Therefore, you need not have something more than just the word rose. However, by way of abundant caution, a radial graph of seven dimensions has been filed, which shows the components of rose, which has been worked out by the Prayagraj Technology IIIT Institute by 3 scientists, and they have given a radial graph showing the breaking down the smell into 7 different vectors, and how much of it is floral, how much of it is pungent, how much is woody, etc. And that has been filed to show that it can be graphically represented also. And just as, colors are normally explained by reference to a Pantone shade, but there is always a protection of a range. So if you have red as a color which is protected for Colgate toothpaste, somebody says mine is a light red or a darker shade of red, does not get him out of the infringement spectrum. There's always a deceptively similar range on either side, like a spectrum of protection. Similarly in smell, if the smell is slightly different, so long as it's not strawberries, and so long as it's not cherries, and so long as it's not some other flower like a lily, then it is easy to ascertain it is distinctive, as much as a pink colored bag on a conveyor belt is distinctive, suddenly stands out, pops its head out, you can make out. And it's totally arbitrary in relation to tires. So being totally arbitrary, being distinctive, being unique and well known to everybody, from the child to an old person, you know the smell of a rose, therefore it is protectable. And it is not really requirement of the law to have it, to have a technology to demonstrate that it is, can be represented on paper. Even the word can represent it. But by way of abundant caution, there is a representation which has been provided to the patent office as well, to the trademark office. So hopefully we should be able to at least get the journal. We don't know, Mr. Abraham and his clients might oppose that. But it'll be the first case in India, and I think we have to push the envelope forward. I think it's important to remember that rule, that if we were always to fear, oh, what will happen if to prove infringement and all that, if we were to fear that, the law would never develop. I think it's developed in other countries. I've cited 26 examples of smells that have been protected in various countries in the world, and I think we should make a beginning.
Fantastic, sir. That's how the law evolves. Now, definitely when it comes up, can you hand over the mic here? So that's also that if there are no oppositions and it gets up and there are the improvements comes and judicial precedents comes out and the statute also may be amended sometimes. Thank you, sir. Thank you for your inputs. And so interesting it happened yesterday and today we are listening from your mouth. Thank you, sir.
Yeah, I was just thinking about opposition, for instance. So, talking about rose, yes, rose does conjure up a smell in the mind. I just did a Google search rightly, just now. What Google tells me is that different colored roses indeed smell different from each other. Generally, red and pink roses have the most traditional rose scent. That means we know there's something called the traditional rose scent. While white and yellow roses often smell like violets, lemon, nasturtiums, and even orange. And orange roses can have a fruity fragrance note. So therefore, is the mark a pink rose or a red rose or a violet rose? And do we have to differentiate? Right now, of course, you have the first mark, and I guess it's a rose. I can assure you, once I have the first whiskey, I will not be able to distinguish the second one from the first one.
It's a caveat now. Anyhow, thank you, ladies and gentlemen, and it's a wonderful panel, and thanks for the inputs from such a distinguished legal luminaries here. And I'm thankful for the panel speakers, everyone prepared well, and I'm sure it is very interesting. Thank you for your patient time and patient listening. Thank you.
Thank you very much. I think that was a fantastic panel discussion on impact of emerging technologies on non-traditional trademarks. It even had a non-traditional ending. So I'd like to now call upon Dr. Venkat Reddy, Senior Associate with a PhD in Law, to kindly felicitate the panel members, starting off with Ms. Silke Freund from Beaumont and Beaumont. Next, Mr. Philip Abraham from Subramaniam and Associates. Next, Ms. Paulom Mehta from Lex Orbis. And now, Mr. Ashish Chang from K&S Partners. Now I'd like to call upon Dr. Agarwal, Honorable Founder GIPC, to felicitate Dr. Venkat Reddy, Senior Advocate and with a PhD in Law. I'd like to request the panel members to pose for a group photo. Thank you, distinguished panel members.